instance of those two hijackers in San Diego and their intersection with the informant, obviously, a very fruitful opportunity for exploitation, intelligence information, maybe in the best of all circumstances leading to prevention. It would have been helpful. It would have been helpful for the FBI at that particular point in time to know the names of those two individuals, that the information which was generated in the January 2000 physical surveillance, not by the CIA but by a liaison agency, if that information and the initiation for that surveillance, which were phone calls to a central number, which you're well aware of, which plays a integral role not only in the East African bombings case, but also in the Cole investigation. The June meeting when 3 but not all of the photographs were disclosed to FBI agents, and the subsequent description of those events. If all of that had worked the way it could have worked, and that informant, as well as informants all over the FBI's domain, were tasked to find out information about two specific people, you could have had a completely different result.
As described in the factual chronology, the FBI had several opportunities in the spring and summer of 2001 to obtain critical intelligence about Khalid al-Mihdhar and Nawaf al-Hazmi. Although the FBI and the CIA were discussing al-Mihdhar, Khalid, and the USS Cole investigation throughout the spring and summer of 2001, the FBI did not become aware of the critical intelligence involving Khalid al-Mihdhar's U.S. visa and subsequent travel to the United States until late August 2001. As we discussed above, we believe the systematic problems regarding information sharing between the two agencies contributed to the FBI's failure to obtain this information earlier. The restrictions within the FBI also contributed to the FBI's failure to acquire critical information about Nawaf al-Hazmi and Khalid al-Mihdhar before September 11th. By the summer of 2001, the effect of the various restrictions within the FBI on information sharing, commonly referred to as the wall, had resulted in a nearly complete separation of intelligence and criminal investigations within the FBI. This separation greatly hampered the flow of information between FBI personnel working criminal and intelligence investigations, including information concerning Nawaf al-Hazmi and Khalid al-Mihdhar in the summer of 2001. In late 1999, the FISA court had become the wall for purposes of passing FISA information on targets of a particular terrorist organization from FBI intelligence investigations to criminal investigations. Any information that intelligence agents wanted to give to criminal agents had to be provided to the FBI's NSLU, which then provided it to OIPR, which then provided it to the FISA court, which then had to approve the passage of the information to criminal agents. In addition, after the FISA court was notified in the fall of 2000 about errors in approximately 100 FISA applications, a significant portion of which related to the FBI's representations about the wall procedures in al-Qaeda cases, the FISA court imposed new restrictions on the FBI's handling of FISA information. The FISA court required a certification from all individuals who received FISA information stating they understood this requirement. The FISA court exempted CIA and NSA personnel who often received FISA information from the FBI from this certification requirement. But the FISA court required that the CIA and NSA indicate on the information they provided to the FBI whether the information had been obtained based on FISA information previously provided to them by the FBI, called FISA-derived information. In response, the NSA decided that it was more efficient not to delay dissemination of intelligence while checking to see if it was derived from FISA, and it therefore placed a caveat on all NSA counterterrorism reports to the FBI, stating that before information could be considered for dissemination to criminal personnel, the FBI had to check with the NSA General Counsel about whether the intelligence was Pfizer-derived. Once the NSA determined whether the information was Pfizer-derived, the FBI had to comply with the wall procedures for passing Pfizer-derived information to criminal agents or prosecutors. If the information was not Pfizer-derived, it could be passed directly. FBI headquarters personnel became wary that any involvement of criminal agents in intelligence investigations could present problems for the FBI with the Pfizer court. A former ITOS unit chief described the Pfizer court certification requirement as a contempt letter and said that it had shut down the flow of information in the FBI. He further stated that FBI headquarters employees became worried that any misstep in handling Pfizer information could result in harm to their careers because an FBI agent was banned from appearing before the Pfizer court and OPR began an investigation on him. These three factors, the court had become the screener in al-Qaeda cases, the certification requirement imposed by the Pfizer court, and concerns about violating the court rules, combined to stifle the flow of intelligence information within the FBI. FBI employees described this to the Office of the Inspector General as the walls within the FBI became higher over time. New York FBI agents told the Office of the Inspector General that the walls were viewed as a maze that no one really understood or could easily navigate. These walls affected the FBI's personnel discussions about the al-Mihdhar information at the June 11, 2001 meeting in New York and the FBI's decision to open an investigation to locate Khalid al-Mihdhar in August of 2001.